hallway and talked to their attorneys, suddenly, both Matt Garcia and Jesse Parks had a coordinated story about these monologues and how they come up with them. Members of the jury, that's not a coincidence. So let's follow that script to the third and final thing. The cab where that copy was found. Because members of the jury, when Matt Garcia and Jesse Parks got into a cab with Devin Harris, they admitted to what they did. They admitted to stealing Alex Taylor's script. And it's not like you have to take Devin Harris's word for any of this, because the evidence, it couldn't be any clearer. Fact. The only file on this flash drive is a document called the argument. Fact. That's the same document as the one that was found on Alex Taylor's computer when Jesse Parks borrowed it. And fact. Neither Trifecta Entertainment nor Jesse Parks has been able to produce Jesse Parks' flash drive since Devin Harris produced this one. This isn't rocket science, members of the jury. It's proof that this is the flash drive Jesse Parks used to steal Alex Taylor's script off her computer. At the end of the day, members of the jury, that's just it. Because for Jesse Parks, she knew that Alex Taylor had a good idea. Knew Alex Taylor had worked hard on her script. Knew Alex Taylor is the person who deserved that job. And Jesse Parks, she claimed it for herself. Claimed something that belonged to her friend and took it as her own to get ahead. Members of the jury, if you follow that script, from the computer to the copy, and from the copy to the cab ride, you'll see it leads straight back to the company that stole it. That's why we ask you find Trifecta Entertainment liable. Thank you.
Before I proceed with closing statements, might I request the opposing counsel deconstruct all of the demonstratives except the blow-up of the screenshot of the flash drive?
Sure.
And that I might set up a demonstrative with my own.
Certainly.
Would you like us to leave the easel as well? Or
Yes, please.
That'd be
Okay.
great. Good.
Yeah.
Thank you.
Oh, sorry.
Me?
And just to check, are these both visible to everyone?
Yes.
Great. May I proceed?
You may.
May it please the court, opposing counsel, members of the jury. Alex Taylor's got a lot of nerve. She came in here and sat on the stand and told you over and over and over and over again that Trifecta stole her play. My play, she said. Told you over and over again, time and time again, that this was her play, she wrote it was her idea. When the evidence has shown that that was a lie. This wasn't Alex Taylor's play. Not the idea, not the structure, not the words, none of it was hers. It was Trifecta's. And you can't steal your own idea. I mean, doesn't it strike you as a little bit odd that every single time the plaintiff counsel gets up here, they act as though it's some sort of incontrovertible fact that Alex Taylor wrote this play? That she wrote it in 2013, that she wrote it by herself? I mean, one of the first things Ms. Grandi said on her opening statement was, it is undisputed that Alex Taylor wrote this play. But where's the evidence? I mean, sure, Alex Taylor took the stand and she told you she wrote the play. But of course she did. But she didn't have any drafts, she didn't have any notes, she didn't have any outline, she didn't have any evidence of when she wrote it. No evidence to demonstrate that she wrote it before May 31st. And then you heard from multiple other witnesses. Witnesses who she admitted were her friends. people who she talked to about her work. But could any of them tell you that she ever mentioned a play with audience voting before May 31st, 2013? Could any of them tell you that she mentioned a play with an argument in Act 1 before May 31st, 2013? Could any of them tell you that she mentioned a play with two separate second acts before May 31st, 2013? The answer is no. Not one witness could tell you. Not Devin Harris, not Jordan Rosenthal, not Matt Garcia, not Jesse Parks, not Isaac Anderson. Not one witness could tell you that she had any of these ideas before May 31st when she saw this folder. In fact, you heard quite the opposite. Mr. Anderson took the stand today and he told you that on the same day she saw this folder. She walks into his salon for her first haircut and she tells him, I don't have an idea. Nothing concrete. Nothing I could turn into a play. Now, Trifecta Entertainment, on the other hand, you heard that they did have an idea. You heard from Matt Garcia that she had an idea in 2012. You heard how she wrote that idea, how she developed that idea, how she did research, how she did background. And unlike the plaintiff members of the jury, we actually brought you the proof. Didn't have to. We don't have the burden of proof, but we did. Because you see, you heard from Mr. Anderson that in January of 2013, before she ever met Alex Taylor, she walks into the salon and she tells him that she has a play where Act 1 culminates in an argument. She tells him she has an idea where there's a vote at intermission. She tells him she has an idea where the vote determines Act 2, where there are contrasting emotional tones. She tells him all of it before she ever meets Alex Taylor. This was Trifecta's idea. There's no getting around it, and you can't steal your own idea. But you know what you can do? You can steal your boss's idea. You heard today that that is exactly what Alex Taylor did. You heard how. May 14th. At this point, her play is just a simple play about human emotions. As she said on direct examination, she's having trouble coming up with what to do at the ends, and there on the table is a folder. Great ideas on the front, and all of Matt Garcia's ideas inside. Matt Garcia leaves the room. Alex Taylor is alone, and she just takes the piece. And sure enough, less than a month later, she has a draft of her play. But this time, it's not such a simple play about human emotions. This time, it has an argument in Act 1. It has a vote in intermission. It has a vote that determines Act 2 with two divergent acts. And so it's no wonder that May 31st, when she sees this folder again, she's pretty excited to have a look. She sees this folder. She takes it home for 3 days. And again, Matt Garcia's ideas are just inside. And at the end of those 3 days, she submits for copyright, submits her final copyrighted version, and this time, she has those last things, the things she told you on direct examination were the last things to go into her play. Those monologues opposing counsel talked about so much, the monologues which were identical to the ones that Matt Garcia wrote. You can't steal your own ideas, members of the jury, but Alex Taylor could. Now today, the plaintiff wants you to believe this is copyright infringement. But the law in Midlands is very clear. You can't just steal someone else's idea, call it your own, copyright it, and then sue the person you took it from. That's just not the way it works. And so this case, it comes down to one simple question. Who stole the play? Alex Taylor or Jesse Parks? Now, the plaintiff wants you to believe that this play was stolen by Jesse Parks. Members of the jury, their story, it doesn't really make sense. I mean, what evidence did they give you? They came up here, and for the entire second half of the trial, all they did was try to attack Ms. Garcia, Ms. Parks, Mr. Anderson on things they said in February. But time and time again, Ms. Garcia, Ms. Parks, they said exactly the same thing. They said what they said in February was the same as what they said on the stand, is the same as what happened. They told you in February, as they said on the stand, that the entire play was written by Trifecta Entertainment, written by various members of the writer's staff. They said on the stand today, the entire play, it was written by Trifecta Entertainment, by various members of the writer's staff. And members of the jury, that is the truth. And sure, they didn't mention the word monologues. That's what opposing counsel wants to say. They didn't mention the word. But members of the jury, they told you what you needed to know. They told you that line for line, word for word, this play was Trifecta's. And that is exactly what they said on the stand today. And what did opposing counsel manage to do with their own witnesses? Well, they told you they were going to prove two things: access and substantial similarity. Well, let's talk about access. They told you they were going to be able to prove that she had a copy. Think about their story. It doesn't make sense. I mean, they want you to believe that Jessie Parks copied this play in 2013, that she put it on a flash drive, that she just carried that flash drive around for months and months, years and years, even after her company switched to the drive. They want you to believe that she just happened to be carrying a flash drive where the only file, the only one, was this play. No other work, no identifiers, nothing. It doesn't make sense. Until you remember where you heard that at. You heard it from Devin Harris, the man who admitted on the stand today that Trifecta makes him furious. The man who admitted that the same day Alex Taylor told him about this lawsuit, he starts to go undercover. He brings you this flash drive, the flash drive identical to all the other ones he has. This isn't proof, members of the jury, whatever opposing counsel says. And so that brings them to the second thing they said. They said they were going to prove substantial similarity. And sure, these plays are similar. We've told you that from the very beginning. They are so similar, they must have been copied. Every element of these plays that we put up here today was the same. These plays must have been copied, just like opposing counsel says. But members of the jury, the question isn't were they copied? Are they similar? It's who copied them. And you can't steal your own idea. But Alex Taylor could. Find Trifecta, not lie. Thank you. Would you like me to deconstruct?
Sure, thank you. Rebuttal, Your Honor?
Would you like me to leave yours up, or?
I'll grab it. Thanks. Rebuttal?
Please.
Sure, I think it's up there.
Okay, thanks. Members of the jury, sometimes what tells you the most is what someone does, not what they say. Because Miss Bay, she just stood up here for 9 minutes, but before she said a single word, she took these monologues down. And she did that for a reason. It's because Miss Bays wants you to ignore the fact that an outline in a folder, a one-page outline, can't explain all the similarities between these two monologues. It's because Miss Bays wants you to ignore all of her witnesses' changing stories about these monologues. It's because Miss Bays wants you to ignore all of these words. But members of the jury, we ask you, don't ignore these words. Don't ignore the changing stories of their witnesses. We ask you follow the script. From the computer to the copy, from the copy to the cab, and from the cab straight back to that company. We ask you find Trifecta Entertainment liable. Thank you.
Thank you all very much. We are going to take a brief recess.
And that is the end of the 33rd American Mock Trial Association final round. That was UVA versus Yale It is a direct repeat of last year. Let's see if we have the same result or if UVA is able to take it this time. Jonathan Woodward is not here right now because, as tabulation director for the American Mock Trial Association, he's currently down there in the trenches with those judges trying to find out who actually won. There are 7 judges in that round, and something that you all might have noticed if you're watching this at home is that you saw some of the judges in the front of the room, others to the side. In some instances, the witnesses and attorneys acknowledged the gap between those judges. In other instances, they just spoke directly to those judges on the side, not in the bench near the front. I think what this round is going to come down to is a referendum on what is credible, what in mock trial is trustworthy. And this was hammered by the University of Virginia during the 4 impeachments they conducted of Yale's witnesses. I think Yale's witnesses went out of their way to talk like real people do, to stumble over their words sometimes if it seems like a good bit of acting. Whereas Virginia is very scripted, very slow, very sedate, very coached, and very memorized. It's going to come down to what those judges think. And I don't think that at any point either team tried to play the other team's game. So you might see a very split round, or you might see that it went all one way or all the other. As to those closing arguments, it was more of the same when it came to that stylistic split. We saw from Virginia the classic formula of open with an attention getter. In this case, I thought a very effective use of famous movie quotes. Then pivot towards their theme, which is follow the blank, follow the blank, follow the blank. Then walk through the 3 key areas of analysis. And in this case, bring in some very interesting real-time trial-based analysis, and that was about how the stories seemed to all of a sudden match up after the defense went on break and then came back. I thought that was very effective and relevant to the trial. And they were applauding. Let's see what the judges have to say.
Tom, you want to start?
TG.
Okay, Ron. I think there's just maybe one little thing that would be helpful for all of you. In the trial of a case, you have to be softer a lot of times, and then more hard-hitting when it's important. That's much more effective. If you're a little too hard-hitting on everything, you kind of lose some of the persuasiveness. You know, gee, your hair really looks good. What a pretty dress. Will you marry me? Well, somehow those things are a little bit different. And so I think that would be the only little thing. And here's the truth. This is unbelievable. You guys are really terrific, honest to God. And your witnesses are as good as you guys. I mean, that's really terrific to take a very complicated fact situation. It's one thing if we tried a case of who ran the red light, something that you have a knowledge of because you're going to call and so on. Here you have this very complicated fact situation, very complicated legal issues, and you haven't been through more than 4 years of law school, I know, and to be able to digest all that, to communicate, is really superb. Now let me tell you one more thing. One of you is going to lose, and one of you is going to win, but you didn't. You didn't lose. You didn't win. You people were totally phenomenal. I really mean that from the bottom of my heart. And I've done this a while. And the one thing that if you're...
Who's my law school professor?
You got a C minus, but what the heck. The one thing that is so exciting about the practice of law is the trial courtroom. That's all there is to it. It's so exciting, and then the jury comes back. They have a verdict, and you're about to get your report card. And you go back to the office and you say, I won the case. Or you go back to the office and you say, I lost the case. And you're telling the truth, because the better lawyer wins the case. When the drunk truck driver runs over the kid on the sidewalk, That case doesn't go to trial. Cases like this go to trial, where, there's a lot of up-in-the-air stuff about it. And I tell you this, it's such a fun idea, this trial practice. If you're going to be a lawyer, how about being a probate lawyer? Someday everybody's gathered around the table, and they say, gee, did you look at the way he handled the pretermitted heir? By the time anyone knows you did a good job, everybody's dead. The guy's dead, you're dead, etc. Family law, that's a good one. By the time that thing is over, the lady hates you, the guy hates you, the judge can't stand you. I mean, that's just awful. But the trial practice is so exciting. The business of persuasion is really cool. Anyway, you people are absolutely terrific. Your witnesses were phenomenal, and it was a pleasure to be here. I should say one more thing. We're just lawyer guys. That's fine. We should be here. That's our job. To have a justice of the Court of Appeals who was in New York this morning at 7 o'clock, to have a federal district judge, and to have the person in charge of the courtroom here is unbelievable. And they really deserve it. Those three people.
So I have to follow Tom, of course, right?
First of all, I want to congratulate all your loved ones who have been very supportive of you from the very beginning. Because I know that this has been
Difficult. I'm sure there's been many times when you were crying or felt like crying or just smacking the wall. But I have to hand it to the parents, the loved ones who've been supporting the students throughout this process. And so let's give your loved ones a nice big round of applause. And so the one critique that I won't completely harp on, which is what Tom talked about, is you don't always have to shout to make your point. Sometimes just being a little quiet or lowering your voice is going to make that impact just as forceful as yelling as to what that point will be. So be mindful of that. But I've got to tell you, I've been doing this not as long as Mr. Girardi has, but as a public defender for over 2 decades now, I can tell you guys did an amazing job, every single one of you. And I would love to have many of you as my witness up against a prosecutor, because you were able to weasel your way out of answering the questions, which is just beautiful and masterful. The one thing that you have to keep in mind whenever you're making a presentation, whether you're dealing with saving somebody's life or freedom or defending a cause or representing a company, what's going to make you the most effective is to connect with the folks. Don't talk down to the people. Be real. Be yourself. Because it's one thing to act, it's a different thing to be. So just be yourself. Try not to act, because sometimes it becomes a little bit too overemphasized. But all of you were being yourselves, which was, I think that's the height of when you were the most effective. But overall, you guys were outstanding. So congratulations to all of you.
Judges, I don't know who else there is to thank, but if you have a pet, let's thank pets. Just think of the feeling that you're having right now as you sit and you wait, wondering who won, and think about that angst, that anxiety, the adrenaline pumping after you've tried a real case, after you've tried your first murder case, and you're waiting for the jury to come back. Think about that and ask yourself if you really want to be a trial lawyer. Because Clarence Darrow once said that the real lawyers are the trial lawyers. And I agree with that wholly and completely. You've done a masterful job today. Just when I thought I was going to go with the plaintiffs, the defense drugged me back in. And in the end, I'm still a little bit confused. And so somebody did a good job. In arguing these cases. I understand that one side had a more difficult time case than the other, but I think the defense did a good job. You know, you use y'all in that, you know, in that play. It makes me think somebody from Tennessee must have written it. You know, but of course, I think it was a great problem. You know, great push either way. I think Tom's right, you know, and in a case like this, who wins or loses may depend on the lawyers, who the lawyers are and how the lawyers try the case. And you all did a fine job. You should be very, very proud of yourselves. Your coaches should be proud of you, and congratulations.
Oh, y'all. Picking up on the theme of the first two commentators about being shrill and strident and raising your voice and being real forceful, I agree with them. And I tried a case many years ago where my client was a farmer developer from a rural county in South Carolina, and we were up against the Environmental Protection Agency. And there was a lady with the EPA on the other side. And during the course of the trial, he was asked, "Have you ever met Mrs. EPA Lloyd?" He said, "Oh, yeah. I'll never forget it." And so the lawyer said, "Well, why do you remember it so well?" He said, "Well, she walked in the room and jumped on me with all 4 feet." Now, I don't mean to be offending to you ladies, but I just thought it was an illustration of that point. Tom says you got to learn how to lose, and I agree with that. Really good lawyers go to court and lose their stomach for it. They don't know how to treat those two imposters both the same. The really good trial lawyers walk out of the courtroom having lost, go back to their office and pick up the next file. Just like the doctor in the emergency room who loses 2 or 3 patients brought in by ambulance after a big wreck. He tries his best. And after hours of hard work, one or maybe both of them die. And you know what he has to do? He has to come back to work the next day and get back on with it. That's what you call professionalism. And we lawyers have to be professionals about how we react to the outcome or the disposition of a case. There was one point in the case that I saw in the other trials, and you people didn't go into it, and maybe you made a very conscious decision not to. It's that text exchange. You're not nodding your head. In the text exchange, it ends with an instruction to someone with the defense, as I understand it, to erase the whole exchange. Remember that? You saw that, didn't you? Well, in the case that I saw that used, it occurred to me that could be the real basis upon which to build a great plaintiff's case. And juries are always on the lookout for who's wearing the white hat, who's wearing the black hat. And when they see evidence that somebody tried to destroy evidence, eliminate evidence, they don't like it. And a good lawyer can use that to portray the other side as being less than candid and wanting to keep the truth from coming before the jury. Juries don't like the idea that they're getting less than the told story. So I saw it used effectively in one of the earlier trials that I judged, and it just occurred to me that maybe y'all could have used that on the plaintiff's side too. But I thought you all did extremely well. Your knowledge of the rules of evidence, your knowledge of proper courtroom etiquette, your ability to forcefully argue your points and continue to ask to be heard. I find that very impressive. And that's something that good lawyers do. You've got to make your record. If you don't make your record at the trial court level, you don't have any chance whatsoever on appeal. You've got to press issues. You've got to get adverse rulings, because only those adverse rulings will form the basis for your appeal. So I was honored to come out here and participate in this. Abota is very honored to be a supporter of the American Mock Trial Association tournaments. And as I've told others with the organization here in Los Angeles, I hope we can continue to be generous and supportive of your efforts in the years to come. Thank you.
Sucker, or the ex-native Angelino. So I will just tell you that I am a federal court judge, and we try copyright cases. And I have tried copyright cases. And this was, you folks are just as good, if not better, than the lawyers that I see arguing copyright cases in front of me. So you should be very proud of yourselves and what you did tonight. I think that I'll just give you a couple of nits. You did great. You'd be most welcome in the federal court. We're a little formal in federal courts, all this walking around. We don't like that.
How about the well?
We don't like that either. Don't get in my well. It's kind of making me a little nervous, And I don't like that. I'm going to speak up. But you guys were fabulous. You learned when to read the judge. Read the judge. Always reading the judge. Read the jury, read the judge. Don't snatch defeat from the jaws of victory. You learned that. That was really great. And you knew when to stop, which is a skill and an art and an instinct all mushed together. Substantively, your rules, please, you could teach the lawyers that appear in front of me the federal rules of evidence. 615. I was like, I know that. Somebody's talking about the rules. It was great. So I entreat you to go to law school, practice your craft. It truly is a craft. These folks over here really do work at it. And I'll have some specific comments. I would say if the jury is always watching you, okay? So if you are not pleased with a ruling or you wanna get in there and argue it, keep your poker face. Thank you.
Judge Brazil.
Yes. I'd like to echo what's already been said, and I want to say to all of you, it was really an outstanding job here today. I have been practicing law, 19 as a lawyer, 15 as a judge, and many times I had to pinch myself up here to say, these are college students. These are not lawyers. You were just all incredible. I thought the calm and the patience that everyone had was truly excellent. One of the things I liked, and you could teach some of the lawyers sometimes, is the civility and the professionalism that you all displayed throughout this entire proceeding. We try to stress that as judges. We try to stress that to the members of the bar more and more, and you were just a real fine example of that. I thought, in terms of things you might want to think about in the future, is sometimes you can be a little bit too aggressive, and sometimes when you make a point, you want to pause. Sometimes silence is good so that we can absorb what's been said, so that we can really acknowledge that point. You don't want to rush through it, and sometimes it gets missed. All of you, for both the plaintiff side and defense side, who were playing the lawyers and asking the questions, I genuinely believe each of you have a very bright future in the law. I certainly encourage all of you to apply to law school. I think you will be excellent lawyers. Just what you've demonstrated here tonight is really just unbelievable.
Federal courts hire law clerks, too.
Yeah, they hire law clerks. And we are at a very good law school, namely Loyola, so I hope to see some of those applications coming in to Loyola soon and some of the other law schools, because your performance here is just first rate. I was just so pleased to see it. And those who played the witnesses, very entertaining. You all have a career in theater, I think. Mr. Tennessee over there. All right. I have to single you out, but I thought all of the witnesses were truly amazing, and they kind of brought the character to life, which is very important. And you'll find as lawyers, you have to kind of bring the story to life. Every case is a story, and it's a people story. So getting that story out, making sure the jury gets it and understands it is very important. All of you were incredibly well organized. It was easy to follow. The questions that you asked were very concise. And one of the things you did that all of us as judges like is you didn't waste time. You kept things moving, you kept things going, you kept it concise, you kept it to the point. We weren't scratching our heads or or wondering out loud. And I have a terrible habit of when I don't understand something, I grimace, I make funny faces, so people know right away when I'm confused. So I really appreciated the fact that I didn't see any of that tonight. So I just want to end by saying great work. Again, to your families and your support groups, you should be incredibly proud of all of them. The coaches, since I haven't had anybody thank the coaches too much, whoever you are, you did an incredible job. Yes, let them stand up. And there are no losers tonight. Everybody's a winner. Everybody did their best, and really, super job. Thank you.
And I really do echo what everybody else has said. You all were terrific. One of the greatest things about being a judge is to have the opportunity to sit in a trial and watch the art at work, and it was really a pleasure tonight to do that. You all were so nice to each other and to the judge. I mean, very often everybody kept their poise. Very often we'll rule and we'll get major eye rolls, and no one got frustrated. Everybody stayed right on point. I loved the themes that you both had. This follow the script and keeping that theme from the beginning to the end. I was completely surprised by the defense position. I said, of course it was stolen, but it's them. It was, I thought that everything was very well done, and I truly loved the witnesses. I must say, Alex Taylor, I never would believe that you would have kicked that filing cabinet. I didn't buy that for a minute. Everybody was so good and so in character, and it was like I said, it was a complete pleasure. And you are welcome in my court anytime. I'm on the Court of Appeal, but that's after you finish your trial. Truly, I do hope you are all considering being lawyers, because we need all of you in our profession. So thank you for a wonderful job.
Good evening, everyone. First, I want to thank for their time and their insights this fantastic panel of judges this evening. Thank you all. We would like to thank our sponsors that made this happen, our host, Loyola Law School. Our championship round sponsor, Girardi Keese. And the sponsors of this championship tournament, UCLA Anderson, the American Board of Trial Advocates, ABOTA, and the ABOTA Foundation. It's time now to meet the competitors from this fantastic trial. First, our plaintiff was the University of Virginia. Alex Taylor was portrayed by Deanza Cook. Jordan Rosenthal, portrayed by Frankie Piacenti. And Devin Harris, portrayed by Dennis Tincelli. Plaintiff's counsel this evening was Sabrina Grandi. Casey Schmidt. And Alexandria Piacenti. For the defendant this evening, Yale University. Sarah Cohen. Portraying Jessie Parks was Allison Dew. And Isaac Anderson was portrayed by Adam Chase. Counsel for the defendant was Michael Burns. Andy Parker. And Elizabeth Bays. These 12 students, along with those who competed in the earlier rounds of this tournament, are now all AMTA All-American attorneys and witnesses, respectively, by virtue of competing in this trial. Congratulations to all of you. This monstrosity is the Richard M. Calkins Award, named after the founder of the American Mock Trial Association. It is presented each year to the champion of our tournament season. This trophy has spent time previously in both cities. Last year, it spent a year in New Haven. These are defending national champions. In 2006 and 2007, this trophy spent the year in Charlottesville, Virginia. And on behalf of the American Mock Trial Association, it is my great honor to announce that by a 6-1 decision of our judging panel, the trophy is returning to Virginia.
Six to one decision. The trophy returns to the University of Virginia Cavaliers. That is incredible. It's their third national title, but there's a lot that Yale also has to be proud of. Again, this was their third consecutive national final round appearance that, to my knowledge, has never been equaled in the history of AMTA. So I'm very curious to see what those judges said, specifically what's on those ballots. John Woodward, the tabulation director, should be returning in just a bit, and I think he can tell us how the judges ranked the attorneys, specifically what the point differentials were on all of those ballots. So it seems that in the end they preferred the style and structure of the University of Virginia, but we don't know exactly what they thought of those witnesses or those attorneys. I think at the end of the day, I felt myself a bit more persuaded by Yale's closing argument than Virginia's. As a matter of fact, I thought that Yale did a very good job pointing out inconsistencies, and at the end of it, I felt that the rebuttal, while clever in pointing out that Yale had taken down one of the demonstratives, was non-responsive to the substance of that closing argument. So I'm curious to see what the split was on statements as well. Very shortly, we should see John Woodward and hear what he has to say, but just look at that image of them celebrating there. It must be a tremendous feeling to come so far in such an incredibly competitive activity and to win so much. Good job to all of them.
Great job. Great job. Thank you so much.
For us too.
Oh no, y'all 2 times in a row. I'm a second year.
Thank you guys so much.
Oh, you didn't? You get paid? Oh my goodness. You said the appeals judge, and I was like, okay, wait, federal judge, appeals judge. Got it. Oh my God, New York. And you say the wait this is Thank you so much.
Happy New Year.
Well done.
here with a newly crowned national championship closing attorney. How does this feel?
Really, really wonderful. Thank you for asking. It's really exciting.
Can you describe to me your road towards this title, not only from this year alone, but your entire mock trial career, of culminating in this amazing accomplishment?
Sure. Well, this is my third year in AMTA. I'm a graduating senior, so it's really wonderful and such an honor to have gotten this far, particularly since last year we were in the same round on the same side and the results didn't turn out the way we wanted them to. So the fact that really we've just been pushing ourselves and motivating ourselves from that round until now, it's just really interesting, and I'm really grateful that the tables turned this time.
What would you say were the major changes in your strategy facing off against Yale last year versus this year?
Sure. Well, I think just first and foremost, having been in that sort of environment, that sort of experience before, the exposure was invaluable in terms of just learning how to better adapt to situations, be more reactive to certain situations, and just practicing a lot of hours.
If you had to name a turning point in that trial, a moment where you really felt like you had it, what would that moment be?
I'm not sure I ever did. It was honestly, it was sort of shocking. Really, when the decision came out, I couldn't believe it. I was really excited. I just had a lot of fun every moment, and so did my teammates.
And the last question, if you could give any advice to the new generation of mockers coming up, what would you tell them?
I would tell them to keep pushing themselves, keep practicing, even when you think that, you know, it didn't work out, it didn't turn your way. You can always come back, and you can keep pushing yourself to get where you want to go.
It's an amazing accomplishment. Congratulations.
Thank you so much.
You're welcome.
Hi, Ian.
Hi, we have John Woodward back to discuss the particulars of this round.
Sure. We'll let Ms. Piacenti step off our set here. Let her get back to celebrating with her team. And they are celebrating downstairs, by the way. It's very festive atmosphere down there. That was a fun round.
It was.
Lots of interesting things to talk about, lots of different changes in momentum, lots of different things we've never seen in a championship round before. Don't think there are many 6:15 objections ever in AMTA, let alone in a final trial. So final result obviously is 6-1. And I think a lot of folks think that, you know, based on the way the momentum of the trial went, that's kind of the way it shook out tonight for Yale University. But I will say for them, it's a very young, raw team. And this experience, sort of similar to the way last year helped shape Virginia and get them better for future years, for this year, I think that's going to be the same for Yale University over the next few years. Looks like we have Casey Schmidt here to talk to us. So let's bring him in.
Absolutely. Well, first, congratulations. You are a national mock trial champion. How does that feel?
Feels pretty good. Tomorrow we're going to Disneyland to celebrate.
Seriously?
We are.
That's fantastic. Speaking of Disneyland, that was a roller coaster of a round, I thought. We noticed that you had perhaps the longest build-up to an impeachment by omission, perhaps in the history of AMTA's finals. What was your thought process during that?
Well, you know, when we went into the defense case in chief, I was still a little bit thrown off because we were low on time on direct, but getting back in it, I knew that if Garcia was allowed to say that, if Jesse was allowed to corroborate that, I mean, that was the end of the case. The monologues are the key to our case, and if they could do that, it was going to be game over. And so when I went in there, I knew what I had to do. I knew we had to get the impeachment, follow it up on a second one, and that's all I was really thinking about in that moment.
How much of your case theory was pre-built around this idea that you're going to try and argue to the jury that the story that Matt Garcia and Jesse Parks came up with was something that happened in that very recess, that was a last-second thing they came up with? Was that something you did in your other defense rounds?
No. So, I mean, originally when we're facing more standard defense, it's all based around the monologues, and those are the proof that regardless of what they say, you can't look past the similarities there. The fact that Garcia and Parks came in and hadn't said anything about the monologues in their affidavits, hadn't been talking about anything that until we came into the defense case in chief, we decided that if we were going to do it, that's how you had to do it. That's what they had to have done, is corroborated with their lawyers, huddled, came up with a cop-out, and then went with it.
Now, we've seen in many AMTA final rounds teams building, in some cases, entire directs around minor places of ambiguity in the affidavits, and it seemed like that was Yale's strategy concerning those directs, the ones that you impeached by omission on.
Right.
To what extent do you think this final round will influence how other teams approach cases in the future?
You know, I think it could go either way because this was something that, for those of you who watched last year, that Yale had last year in a few places on at least 2, maybe all of their directs. I think it's part of their style. It's something they're obviously very good at doing and crafting. And so I think other teams might decide whether or not they want to pick it up. But at the end of the day, it takes a lot of skill to be able to execute something like that. And so you have to commend Yale on being able to execute that strategy time and time again.
Absolutely. I mean, go for it.
No, it also takes a lot of skill and strategy to do those impeachments and do them well. A lot of times that's something that less experienced teams just, they're not very adept at sort of the nuance of doing that. What in your preparations, and it was a very short period of time you had to prepare for this case, what helped you sort of get ready for those, impeachable pockets?
You know, I mean, it's easy to look past the little things. When you're thinking about theory and writing directs and crosses and openings and closings, when you only have 3 weeks, it's easy to kind of let the fundamentals slip away from you. And so I think it's important that even when you're crammed for time, you're focusing on things like witness control, knowing how you actually do an impeachment if you have to. The little things that you probably learned when you were a freshman, you've been doing it so long you don't think about. At the end of the day, you win on the little things, I think.
Speaking of how long you've been doing it, how long have you been competing in mock trial?
So I started when I was a freshman in high school, and I'm now a junior. So this is year 7 for me.
So next year is the last year, is that true?
That would probably be the end unless I take a 5th, but...
I mean, where do you go from here? You're a national champion as a junior. What are you going to do next year?
I think it really all depends. We have obviously a great group. Only of the people who are on that team there, only 3 of them are seniors that are going to be graduating, and so I think there's still a lot of potential. I mean, last year we only had 1 graduating person. Everyone else came back. We're a team with a lot of potential moving forward, I think.
What was the chemistry like among your team members? Certainly as an outsider looking at it, it looked like a very cohesive group, which is obviously what you need. You need to look like you're all not only getting along in sort of a friendly sense, but also getting along in terms of the things you have to do during a trial. How did your group work throughout the year and in these 3 weeks before the championship?
I mean, we're a really tight-knit group, and not just our team, but a tight-knit program. I think that's something that you gain when you only have 2 teams in a program, when you only have 16 members. You have a lot of opportunity to really become friends with them in a sense that's not just inside the courtroom and at practice. They really become part of your family and a big part of your college experience.
My understanding is that Yale is an uncoached team. University of Virginia obviously has Toby Heiden's a fantastic coach, sort of at the helm of the program. Ryan Faulkner, a whole lots of other folks, some of your alums helping out. How did your coaches sort of help you, sort of craft your approach to this case as you were working on getting it ready for nationals?
I mean, we definitely couldn't have done it without Toby, and we definitely could have done it without Ryan either. I mean, it really does help when you're all 18 to 22-year-old undergrads with no law degree, having a few people who have seen their way around the courtroom and also been doing mock trial for literally decades. Just having that extra experience under the belt, I think, is crucial to be able to not only execute the plan, but first lay the foundations for what you're going to do.
Well, Casey, congratulations on, again, being an AMTA All-American and appearing in the final round, and we'll let you get back downstairs to celebrate with the rest of your team.
Thank you so much. I appreciate it.
Congratulations.
Thank you.
I'm exhausted. I don't know about you.
I'm so tired.
It's been a long day for those of us involved in running the tournament and certainly being here to sort of administer the final round. But what are your sort of final thoughts to wrap up our broadcast this evening with this 33rd National Final?
I think it's sort of dependent on what the ballots themselves say, right? Were there any issues that you saw indicated by these ballots in the final round?
I didn't have a chance to look at them very quick. Some of them were very close. Obviously, some of the closer ballots, were primarily 9s and 10s. Some of the ballots that UVA took, this particular judge clearly had an issue with Matt Garcia, seemed to respond very well to the other 2 Yale witnesses. This one was more similar across the board in terms of, 8s and 9s for most of the competitors. Again, lots of very high scores. There's very few scores on any of these ballots below an 8. But to the extent that, the judges were deciding between, 8s, 9s, and 10s. Unfortunately for Yale, it looked like their witnesses were more in the 8 to 9 category, whereas the UVA directs were more in the 9 and 10 category. And that's why all of these ballots were single-digit wins, except for one for Virginia with 1 2-point ballot for Yale. So certainly a very decisive victory, but by no means were any of these ballots, a true blowout. All of the judges saw this as a close trial, but I think some of the things that we keyed in on in terms of the issues with the impeachments and some of the things that went on during the Yale case in chief were things that, affected those scores just a little bit, and all of those added up to, single-digit margins for Virginia.
Very well said, John. I think that just about covers it.
All right. Yeah, let's go with who is your top witness and top attorney of the round before we say goodnight?
Yeah, sure. So from that round, I thought that Michael Burns was incredibly charismatic and made the best of the time that he had. But in terms of holding down their side, especially giving that powerful closing argument, I think that Alexandria Piacenti probably took that day. Those are my top two.
Yeah, I absolutely agree on Ms. Piacenti. She was fantastic last year. I think she was even better this year. I really feel that she owned that courtroom. Obviously, the teams don't tell the judges who their captain or lead attorney is necessarily, but it was clear without saying it that she was the lead for that plaintiff's bench. She was really the rock of that bench. And did a fantastic job. In terms of the witnesses, I really liked Adam Chase. I know going with the character witness may be a little bit of a cop-out, but he was certainly, to me, the most entertaining. I thought he held his composure very well during those impeachments. I didn't think the impeachments really damaged his credibility too much, and so Adam Chase from Yale is my pick for the best witness of the round. Although Dennis Tuncelli from UVA is kind of a close second place there.
I thought both character witnesses were phenomenal, maybe the best battle of characters I've seen in an AMTA final round. But in terms of playing a very straight and credible witness in a way that was memorable, Deanza Cook, I really think did a great job, and it's reflected in these ballots. She is ranked very, very highly across all of them.
Yeah, absolutely. Well, I think it's time coming up on 9 o'clock here on the West Coast, which means it is almost midnight on the East Coast. So I think it's time for us to wrap it up and say goodnight for this live stream of AMTA's 33rd National Championship Tournament. Thanks again to our tournament championship sponsor, Girardi Keese, to the tournament sponsors, Aboda, the Aboda Foundation, and UCLA Anderson. So for Ian Lampert, I'm Jonathan Woodward. On behalf of the two of us and the American Mock Trial Association, congratulations to our 33rd runner-up, Yale University, and our 33rd national champion, the University of Virginia. Good night, everyone.